Hello and welcome back to our YouTube channel. Well, it is the lecture 2 of the governance which we had started from yesterday, and the date is 22nd July 2025. So before we will start our discussion today, let me give you the brief introduction about the initiative which we had started from 2nd June 2025, so that if you are new to our channel, you will get more connected with us. Basically from 2nd June we started an initiative by the name Target IAS 2026. Under this initiative, every day we had promised you that we will upload 2 videos, and we try our best to do so. So we upload 2 videos, one in the morning session where we discuss your daily current affairs. We take up the most important articles from the newspapers, we discuss them, we break them down into the simplest language possible, and we show you how they are important for your preparation, whether it would be related to prelims or mains, and what you can get from those articles and how they can be relevant in the exam. And in the evening session we upload another video, which is this video, where we discuss your static syllabus. And we here started with the Indian polity, which we had already completed, and now we are discussing the governance of your syllabus. So with respect to the second part, we had also promised you that by the month of January we will try our best to come by the month of January 2026 we will try our best to complete your full syllabus. We will try to cover every subject which is required for you to clear the exam, whether it would be related to prelims or whether it would be related to mains. We will cover everything what is required for you to clear the exam, but only exception here is that we are not going to cover the optional subjects. That is the only exception. And one more thing I would like to add here, that as we are delivering these lectures, at the same time we are preparing your notes. These notes are very much different from your conventional ones, because usually when you go through the books, you read them and you don't realize, because you may not have the experience of the exams, you don't realize which topic is important for you, which is not important for you. So what happens eventually, when you are reading those notes, you miss many important things which are important for you, and eventually you don't know what to do in the exam. So here we had prepared these notes in this way, that after every topic we had brought the possible prelims questions as well as mains questions if the topic is relevant for mains, so that it will give the idea, it will remain in your mind. When once you are reading these notes, it will show you how these topics are important for you and how the questions can be asked in the exam. So in this way we are preparing these notes. If you want to get access to these notes, you just have to mail us. The email ID is given in the bio, and for these notes you would have to pay only 200 rupees per subject. It is totally optional. If you want to get access, then please do mail us and get the access to these notes. Otherwise, if you like the videos only, do subscribe the channel, do share it with your friends, so that they may also get benefited from this initiative. And please also do write in the comments what else should we bring for you. This initiative is for you, it is about you. We want to improve ourselves too if you will give your feedback. So please do interact with us, do write in the comments what else should we bring for you, where we should correct our teaching style, do tell us. If we need to change our medium, do tell us that too, so that we can help you in the best way possible. Now, without any delay, let us start our discussion from the topic which we left yesterday, from where we left yesterday. Yesterday, as I told you, yesterday's class was full based on the introduction to the governance. The aim of yesterday's class was to get the basic information about the governance, what it is, in nutshell, as per the World Bank definition of the governance. If you want to manage, you want to manage the things, you have the resources, you have to manage it, and the ways in which you are going to manage it, the departments which would be involved, the people which would be involved, and the systems, the public offices which would be involved. When all these collaborate together, when they are in, when they collaborate together, they form the governance system. And we also understood one thing, that in the governance, it is not something which is related to the democratic nature of the country. Country may be undemocratic, but there the governance will be good. Country may be democratic, but the governance may be very much bad. So governance has nothing to do with the democracy of the country. It is everywhere. Governance is everywhere. Whether if we will break the governance into the smaller parts, you will start from your home itself. You will have the head of the family, who would be your father, or if you are married, then you or your wife would be the head of the family. Then accordingly you would collaborate with your parents, you would collaborate with your children, you would collaborate with your spouses, and then you would make up the decisions, and the final aim is the development of the house. Similarly, at the national level, it is the development of the country. We understood that, and in that again I will repeat the point. Governance has nothing to do with the democracy. It is everywhere. Governance is everywhere, but we can differentiate governance on the basis of whether the governance is good or the governance is bad. So on that basis we can differentiate it. After that we saw that there are certain aspects of the governance. For example, transparency is one of the aspects. Then we saw that after there is transparency, there should be accountability should be there. There should be inclusiveness, and all that we discussed in our yesterday's class. So from today, the first topic which we are going to take up is what are the challenges to the governance in India, as we have to discuss it in India's perspective. So let's see what are the challenges to governance in India. So first question which we are going to answer today is this: what are the challenges to the governance in India? Most of the students, whenever we will ask this question to any student or any child or anyone in the college or any person who has not read the governance, who had not understood the governance properly, who is a common person, who is a layman, who will ask this question to them, they will say that the challenges to the governance, they would highlight the issue of the corruption. They would highlight various other issues, that there is illiteracy is the one of the issue, the lack of management is the one of the issue. They will highlight various issues, but you being the IAS aspirants, you don't have to, everybody can answer. When you will enter into the mains, every question is answerable. But what what makes you clear the exam is how good your answer is. Every question is answerable. If such question would be asked in the exam, everybody will say that corruption is the challenge, phalani cheese is the challenge. For example, maintenance is the challenge. Some would say that the population in our country, it is very huge. The demographic dividend, it is very huge. So this is also one of the challenge. Illiteracy is one of the challenge. But at the end, this type of answer would be written by all the students who would have entered in the exam. So what will make the difference? The difference is you have to think out of the box. So let's see what is the actual, let's think like an IAS officer, and let's try to analyze what are the real challenges to the governance in India. So for that, you should have a little idea about the polity of our country. Second, you should have the idea about the social, sociology, little bit social structure of our country, as well as how we are culturally linked to our country. First challenge, if we will see, it is the power dynamics. Power dynamics. It is one of the issue, one of the challenge in our in the governance in India. Well, how now you will say me, sir, please elaborate on the point how power dynamics is the challenge. For example, do you know when we discussed the Indian polity, we discussed the federal structure of our country. We saw that there are three. There is an hierarchy. There are three ways this power is distributed by the constitution. Majorly, first it is the center at the union level, then at the state level it is the state, then third it would be the local governments. It would be the central government, it would be the state government, and it would be the local government. Now what will contribute to the best governance? If all these three all these three, they collaborate with together, and they work in a synchronized manner, and eventually what it will lead to, it would lead to the improvement, it would lead to the development of the nation. For example, we have the local governance, we have the local bodies. What they need funds. On funds, on what they are dependent on, they cannot generate their own funds unless the state approves them to do so, or the center approves them to do so. So eventually they are dependent on the states. And we saw that when we discussed the local government, we saw that one of the drawback of it is that they are highly dependent on the states. And one of the issue with respect to that is that states, they are who are in the state legislatures. They are the people from those constituencies. They don't want to share their power with the local governments. So because of this power dynamics, they don't want to share this power. They want to contain everything within themselves. So what it leads to? It leads to what? It eventually leads to the it eventually leads to challenge. It eventually challenges the governance system. The local governments, they did not work that properly. We have often complaints about the local governments. Even though we had even though we have this structure, we had the 73rd and 74th Constitutional Amendment Act, but the efficiency of the local governments is not good at all. They had least contribution to the development of those villages. It is eventually the state legislatures who belong to those constituencies who then eventually give funds to their own constituencies. In this way, we had seen there are reports that only those constituencies, those villages from where the MLAs are taking part in the elections, they had seen the development rather than the country as a whole, rather than the state as a whole. The issue is with the power dynamics. There is the sharing of power, and they are not, the people, the legislatures, they are not ready to share this power. Then this is the case with the power dynamics. Then the another case, if we look at it, the another issue with another challenge to the governance in India is the social fragmentation. Social fragmentation. What is the social fragmentation? For that, let's try to understand the statement of Ashish Nandi. Let's see what does they say. Let's see what had let's see their let's see what what statement they had made. Let's have a look at it. Let's see what statement Ashish Nandi has made. Let's have a look at it. Ashish Nandi. Ashish Nandi, he has made a statement that in Indian government, the governance in in India, governance is not a single system. What he says, the governance in India is not a single system. The governance in India is not a single system, but a multitude of overlapping power structures, each fighting for legitimacy. But what does he say? Governance in India is not a single system, but a multitude of overlapping power structures, each fighting for legitimacy. So this is the statement which was made by the Ashish Nandi. What does he say? He says that governance in India is not a single system, but a multitude of overlapping power structures, each fighting for legitimacy. For example, as I told you that there is a power dynamics. So there we have the central government, state government, and the local governments, where there is the overlapping of the power. There is the overlapping of the power structures, and what it eventually leads to, it all these power structures, they are fighting for the legitimacy, and it eventually leads to the what? It eventually leads to that the governance gets impacted, because all these institutions, they fight for their legitimacy. The state state legislatures, they want them to be recognized. They want whole power to be to be centralized in the state, in the hands of the state. So in this way, they are reluctant to share the powers with the local governments, and eventually the local governments at the village levels, they get impacted. So similarly, if we look at the second, as I told you, the second challenge is the social fragmentation. Have a look at our social fragmentation. Have a look at our country. We are divided into the castes, we are divided into the religions, we are divided into the regions, we are divided on the basis of language, and all these are fighting for all these are fighting for the for the power structure. Every caste is trying to overlap, every caste is trying to overcome the another caste, every religion is trying to overcome the another religion, even the regions are trying to overcome the other region. And we had seen, because of the linguistic movements in India, how there was anti-Hindi agitation, and eventually with respect to national education policy, even though the government has brought in the law, but the country has not but the Tamil Nadu state, they had not implemented that law. Why? Because there is the governance difference, because there is the social fragmentation in the country. So this is also one of the challenge with respect to that. We had for example, when we had various issues, we have various issues with respect to the religious fragmentation too. If you want to bring in any for example, you have to deal with, Supreme Court has to deal with various cases. For example, Ayodhya Ram Temple, or we can say Kayan Vapi Mosque, or various other mosques which are in about which the courts have to make decisions. So there is huge fragmentation with respect to that, and this fragmentation in the society, the social fragmentation, it is also one of the biggest challenge to the governance. Even though we have the laws, even though we have the judicial judgments, but still it is hard to govern the people because of this structure of our society. Then there is also one third important issue with respect to third important challenge to the governance in India, and that is of the cultural and social norms. Cultural and social norms. For example, we are following certain ideas. Let's take an example of the triple talaq. People are, in the Muslim community, people were following this from the centuries, but eventually, the courts interfered, and the instant triple talaq was banned totally. It was, the parliament brought up the law with respect to the instant triple talaq. So eventually what it will lead to, this breakage from the culture, this breakage from the social norm, it is also one of the challenge. It is not acceptable to the people, even though we have this law with respect to the divorces, but still you would see the communities, the Muslim community, they will try to follow their own religious laws, they will try to follow their own social norms. So this implementation of the law, the implementation of the governance, the idea of it is the challenge to the governance. For example, for the better governance, they will bring in the better laws, government will bring in the better laws, but what are the challenges to it? If we will broadly describe the challenges in India, they would come under these three headings. First one is power dynamics, second one is the first one is power dynamics, second one is the social fragmentation, and the third one would be the cultural. The third one would be the cultural, cultural and social norms, or we can say cultural negotiations. We can say cultural and social norms or cultural negotiation. These are the three important challenges with respect to the implementation of good governance in India. So with respect to this, I hope from yesterday we are discussing the definition of governance itself. We had a huge discussion on it. Now let's see, as we are moving forward, we saw here in today's class till now what we discussed. First we saw what are the challenges to the governance in India. We saw that there is power dynamics, there are different structures, and there is overlapping interests of these structures. When there is overlapping interests, then it becomes the hindrance to the better governance. Then we also saw that there is social fragmentation in our country. We are divided into castes, we are divided into religions, we are divided on the basis of language. There is huge diversity in our country. So it eventually, whenever center tries to bring in any law, for example, with respect to new education policy 2020, states like Tamil Nadu, they are not implementing it. So definitely there is the social fragmentation, and also the cultural and social norm, the cultural negotiations, for example, what you were following from the history. And when the center tries to overcome those cultural wrongs, then it becomes very hard to govern the people, because your connection with the past is something which is more crucial for the people at that time. So these are some basic challenges to the governance in India. So with respect to this, let's see, as we had discussed governance from yesterday, let's see what are the characteristics of the good governance and what are the characteristics of the bad governance. And after that we will take on the Right to Information Act of 2025. We will discuss about that, then we will conclude our discussion for today's class. So let us see what are the characteristics of the good governance. First, characteristics of the good governance. First thing, what should be there? There should be the transparency. If in any government, in any governance, for example, there is a public authority, that public authority is transparent, how they are implementing the laws. For example, there is the government, they had given tender to any political party. On what basis they are given tender to any constructor? On what basis this tender was given to them? How they are spending this money, how political parties are giving tickets to the candidates. If this transparency is there, then definitely it is the good sign of the governance. Once there would be the transparency, then definitely there would be the accountability, which we also discussed in yesterday's class. Accountability should be there. If the country has the if the country, if in any governance the countries have the, they show the accountability, then we call that the governance in that particular country is great. For example, Scandinavian countries, Norway and Belgium, all these countries, they have the good governance. They have good accountability. Where in every country where the accountability would be great, you will see that the corruption in such countries would be very less. For example, if any organization, if you will find any corrupt person and you will own that corruption, and you would restrict that, you will suspend that, eventually it will lead to the accountability of the institution is, when the accountability of the institution is great, they are, they are fully vigilant about it, then eventually it will lead to the, okay, it will lead to, it will lead that it will lead to the decrease in the cases of the corruption. And also there should be the rule of law. you know Nobody is beyond the law. If whoever is convicted, if whatever your states is, if you are convicted, you will be punished according to the law. What the law says, you will be punished according to that. Then transparency, we saw that. Then there would be the participation should be there. Participation from the people, involvement of the people in decision making. Then efficiency and responsiveness, we had discussed this also. Efficiency and responsiveness. And then inclusivity. When all these characteristics are found in any governance, we call that governance is that governance is good governance. These are the characteristics of the good governance. Now what would be the characteristics of the bad governance? Opposite to all this, if there is no transparency is not clear, then we call that there is no that governance is bad governance. There is lack of accountability, that governance is bad governance. There is weak rule of law, that governance is a bad governance. There is no participation of the people, that governance is bad governance. There is no efficiency and responsiveness, there is no inclusivity in the governance, then we call that this governance is the is the bad governance. So let's start now. As yesterday I told you, we discussed those aspects. Now let's start. Let's try to understand these aspects of the good governance one by one. What is transparency and how India has adopted this transparency in its laws? Let's try to understand that in the governance, how India has adopted it. Let's try to understand that now. Transparency. This is the most important feature of a good governance. For example, there is a government, they are making any decision, they are making any law, or there is organization, they are, government is giving funds to any organization, and how that organization is spending those funds. There is Manrega, how funds are given to that, and how Manrega funds are spent. This transparency, if how decisions are made, how these decisions are made. For example, you are giving tender to any company. Why you gave this tender to any company? What was the reasons for that? What were the what were the key features you studied about the company? Was this company in the loss? Do you have any relationship with the company? All these questions. How decisions are made? How decisions are made, how you came to this, what is your opinion about it. So when all this is very much clear, when you can ask the questions and those questions are answered, and they are answered very well, and you get satisfied, then we call that there is a transparency in the governance. So with respect to this transparency, let's see what few thinkers say about it. For you would have heard about Joseph Stiglitz. You would have heard about him. Joseph you would have heard about him. He says that information is a public good. What he says? He says information is a public good. Information is a public good. Access to information should be available to everyone. Access to information should be available to everyone. So he says that information is the public. This Joseph Stalin says that information is the public good and access to information should be available to everyone. That like public good you have, for example, you have parks, you have national highways. They are the public goods. Access to those is access to it is available to everyone. Similarly, the information is a public good and access to it should be available to everyone. When in a state the information is available to everyone, that state becomes tremendous in itself. That scheme becomes egalitarian in itself, because what transparency leads to, it leads to the development of the trust, as we discussed yesterday. How much transparent the relationship would be, that much trust this relationship would develop. As I gave the example as I highlighted the example of the relationship, a simple relationship which you have with your girlfriend or with your parents. If this relationship, in this relationship there is the transparency, then we say that this relationship develops to the highest levels, because there are least chances of any doubt. The trust is the epitome of any relationship. If the relationship has to work, then there should be the trust. Similarly, if this information is held held open, if this information is kept open for the people by the public officials, by the public offices, then eventually there would be the trust between these public offices and the people, and this would lead to the better governance. Similarly, with this regard, we saw that what Joseph Stiglitz says. Then we have another thinker, namely Jeremy Bentham. Let's see Jeremy Bentham, what he says. He says that the more strictly we are watched, the better we behave. He says that the more strictly we are watched, the better we behave. For example, if there is a keen eye on the governments, if governments have to show everything, if they will have to show if they will have to prescribe every information to the people, what decisions they are taking, why they are taking those decisions. So eventually the government itself will think 100 times before making any decision, before giving tender to any companies, before giving these before sending any before giving in these tenders to the people, before having a relationship with these companies, big corporates. They would think 100 times that this question would be asked to them, and they will have to answer. Are they going to justify how they are going to justify it? And these other questions would come into future, and eventually the more they would be watched, the more better they will behave. The more questions we are going to ask the government, the better they are going to behave. If we are not allowed to ask the questions, then government will behave in its own way, and then they will say that the people are so much satisfied with us that they even do not ask the questions. I say that in the country where the people ask more questions to the government, where there is where the presidents or the prime ministers are butchered by the journalists, so much questions are asked to them, that country is the real democratic country. So this asking such questions to these officials, where there is allowance of questions, where the governments are watched more, where there is absolute transparency, then eventually it would develop this nature, that they will try to behave the better, they will try to make the better decisions, and eventually it will lead to the better governance. Then we have another thinker, basically he is the economist. You would have heard about him, Amartya Sen. Let's see what does the Amartya Sen say. Amartya Sen says he emphasizes on the role of transparency in preventing famines and ensuring social welfare. Amartya Sen, he connects famines and social welfare with transparency. It may seem very unique to you. What is the connection between the famines and social welfare with the transparency? But let me elaborate on it. For example, there is a state who is seen some natural disaster, who was under the natural disaster, and because of that natural disaster, there was a loss of habitat for the people. People were forced to move out of their land, and they lost their property, they lost everything in there. maybe that state was hit by floods, maybe that area was hit by floods. Now what is the priority for the government? The priority for the government is to give, first to give relief to those people, to relocate those people and give relief to them. And in once we are giving relief to them, as they have no resources of their own, what it will lead to, if they have no, as they have no resources of their own, they will fully dependent on the government, on the funding from the government. Now let's suppose if this funding the government is giving, but this funding is not reaching to these people, what will happen to these people? These people will die of the famine. They will not have the money to buy food for them, and eventually they will die. It is not they died because the food was not available, but they will die because there was lack of governance. The money was given, the money was released by the government, but this did not reach to the people. So this is how the Amartya Sen, he analyzes, he realizes this point, that if there was the transparency, if there was, media was, if the situation was open to media, and media could have highlighted this issue, that these are the families, these are the people who are not getting food, then government would have came into the action and it would have saved their lives. But there was no transparency, there was no information available to the people, and they died and nobody cared about them. So in this way there is a connection between famines and ensuring social welfare with the transparency. In this way transparency can be such a huge factor in shaping the social welfare of the people. Similarly, we have the example from the COVID-19. If we will ask how many people died in India due to COVID-19, we don't have the data about it. To be more precise, there is no absolute data with the government has given. Even though the World Bank, I guess, World Health Organization, they had given the estimated number that there were excess deaths of 4 million, but it was not accepted by the government. So when there is no data, when you don't know, what was the scenario during the COVID-19, how many people died because of that, how you can suppose, if God forbid tomorrow any other such any other such any other such disease would come in, or any other such pandemic will come in, what would be the reaction from the government? As they, right now they don't have the data. As per the, the point is to understand it. I'm not criticizing the government, please do note that. But the point is, when we don't have the data, what if tomorrow any such other pandemic will come in? How government is going to respond? Are we going to lose so much amount of, are we still going to face so much amount of deaths, which is represented by the World Health Organization? What would be the status, how the government is going to respond? So definitely there is the need of the transparency. It is going to end, for a better governance, there should be the better transparency. So with respect to this, let's move now let's move towards the another topic, which is the Right to Information Act 2005. Let's start this discussion now. So till now I hope you had understood, what are the challenges. First topic which we discussed today, what are the challenges to the governance in India. We saw that there we have three challenges. Leave the corruption and all those cases aside. Majorly there are three challenges. The first one is the power dynamics. The second one is the cultural, the cultural fragmentation. The second one is the fragmentation, and then the third one. Second one is the social fragmentation. Then the third one is the cultural negotiation. Then after that, once we understood that, then we saw the characteristics of the good governance and the bad governance. We also saw that. Then we saw that, what are the characteristics, and then we started to elaborate on that. We started with the transparency, and in transparency we started what are the ideas of different thinkers. In that we first took up the Joseph Stiglitz, what he says that information, in the transparency you need the information, and according to him information is a public good. Access to information should be available to everyone. Then we saw that Jeremy Breton, he also gives the analysis about the information. He says that the more strictly we are watched, the better we behave. Then we saw that Amartya Sen, what does he say? How there is a connection between famines and ensuring social welfare with respect to the transparency. Then we saw various cases with respect to that. Now our topic is Right to Information Act 2005. So where from we get this inspiration of Right to Information Act 2005? We have Article 19 of the Universal Declaration of Human Rights, of the Universal Declaration of Human Rights. We have Article 19 of the Universal Declaration of Human Rights. Let's see what does it say. It says that Article 19 says that everyone has the right to freedom of opinion and expression. Everyone has the right to freedom of opinion and expression. Everyone has the right to freedom of opinion and expression. This right includes, what does it include? It includes the freedom to hold opinions. Freedom to hold opinions, without interference, and freedom to hold opinions without interference from the state or any other higher authority, without interference from the state. Then the second thing, and first right includes the freedom to hold opinions without interference and to seek, receive, and impact information and ideas. And the second one is to seek, receive, and impact information and ideas. So this is the, this according to the Universal Declaration, this everyone, according to the Universal Declaration of Human Rights, according to Article 19, it says that everyone has the right to freedom of opinion and expression. This right includes the freedom to hold opinions without interference and to seek, receive, and impact import information and ideas. So we can ask for this, the idea of right to information is given under Article 19 of the Universal Declaration of Human Rights, that we can ask for the information. It is the everyone has this right to ask for the information, to seek for the information, to receive this information, and import the ideas about it. So with this, how it originated in India, what is the, let's try to understand the brief history behind the origination of the Right to Information Act in India. Basically in 1987, there was a lady named Aruna Roy. She was the ex-IAS officer and she resigned. Her name is Aruna Roy. Aruna Roy, with other members like Nikhil Dev and Shankar Singh. And there were others too. They started an organization called MKSS. These people, they started an organization called MKSS. What is this organization? Kisan Shakti Sanghatan. Mazdoor Kisan Shakti Sanghatan. So they started this organization. What was the focus of this organization? She realized one thing, that government is recruiting the workers. They are working for the public business. They are recruiting these workers for the construction, whatever the reason would be for their work. But there is issue. What is the issue? Issue is with respect to delay in wages. There is often the issues of delay in wages. So in order to find out the answers to it, this organization Mazdoor Kisan Shakti Sanghatan, MKSS, they wanted to find out what is the reason for these delays, and they went to the public offices and they tried to get the information. But every information what they asked for was denied by the public officials. Every information about this denial of wages, every information about the denial of wages was denied by, about the delay of the wages was denied by whom? Was denied by public officers. So they realized that there is a bigger problem in our country, that we don't have the right to information. They can, these public servants, this government, in its nature only, they have this inherited in them, that they hate to give information to the people. So when they are denying this information to us, how can we know how they are working out, what are they doing with respect to that? So in this regard, in Rajasthan, this MKSS organization in Rajasthan, they started the protest. They demanded that there should be the Right to Information Act. They demanded that there should be the right to Information Act, and to their support the CM of the Rajasthan also supported them. But eventually when the government changed, this right to information act was not given to them. So there was again in April 1996, in April 1996 there was another agitation. They announced the protest in Ajmer. This organization, they started protests in Ajmer. Approximately 150 villages took part in it, and it was the first time in the history of Indian independence that so many people came. They are protesting not for getting the jobs, not for the money, not for the food, but they want to get the information. So it was a milestone in itself. They protested, these 150 villages, they protested for they wanted to get the information. In this regard, there was another person, namely Shailesh Gandhi. He also joined it, and he also launched the national campaign for people's right to information, and eventually the draft was created, and right to information came in. In 2005, the right to information came in, when this protest. First it came in the Rajasthan, then it was adopted throughout the country. Now let's look. It was a brief history how it came in. What was the reason why this right to information was demanded by the people. It was the Mazdoor Kisan Shakti Sanghatan. They demanded it, because they wanted to know why there are delays in the payments for the wages of the people, of the laborers. So with respect to that, it came into the picture. Now let's see what are the key provisions of the Right to Information Act 2005. What are the key provisions of the right? First, what does it say? Any public authority means any authority or body or institution of self-government established by the. First, here it describes what public authority is. Any public authority under constitution. For example, it would be CAG is there, Election Commission is there, Union Public Service Commission is there, State Public Service Commission is there. They are the public authority. Any under constitution, if any there is public authority under constitution, or may any public authority by any other law made by the parliament, by any other law made by the parliament. Then third, or by any law made by the state legislature, or fourth, by notification created by the government. Fifth, a body owned or controlled or substantially financed by the government, or NGOs. It also includes NGOs which are substantially financed by the government. All these institutions will have to ensure to provide information so moto. So all these institutions which are the public which are the public authorities may be under constitution. Under constitution has created these public authorities, or by any other law made by the parliament, or by any law made by the state legislature, or by the notification created by the government, or the body is owned or controlled or substantially funded by the government, or NGOs which are substantially financed by the government. All these organizations, they come under the definition of the public authority, and they will have to, all these institutions will have to ensure to provide information suo motu. They will have to provide information suo motu. What is this? When there is the Right to Information Act, you will seek the right to information. You will bring in various legislations with respect to that. You will file the RIT, and what it eventually will lead to, it will lead to bulking of the cases. So what does the Right to Information Act 2005 say? We don't need to bulk up these cases. We have these authorities. We will tell them, please upload the important informations what are required. Please upload them on the websites about your organizations, so that whenever people would want to see them, they would just look at your websites and they would come to know, and there would be less burden on the authorities. So this is the first provision, that all these institutions will have to ensure to provide information suo motu. Display informations on the website. Then how you can request for the information, how you can request for obtaining information. What is the way under the Right to Information Act? Request for obtaining information. From whom I will seek this information? Then the Right to Information Act says that every public authority, every public authority will have to create the public information, central public information officer. They will have to create the central public information officer or the state public information officer. They will create these officers by paying, when for example you want to get the information, every public authority will have these central public information officers and state public information officers. If you want to seek them, you will have to go there, and you will be told to pay certain minimal fees. And if you belong to any marginalized section of the society, then you will not have to pay any fees. And then you will have to give in written form, what information you are seeking from them, what information you would be seeking for them. It should be given in the written form. Or if in any case it is not possible that they would be able to give it in the written form, then they can also give it orally. But here they would, you can ask for their assistance. So this is also the provision how you can file it. You can file it, you can approach to the central public information officer or the state public information officer. This information should be given in the written form, or it can also be given in the orally, but you can ask for their assistance. And when you are asking this information, they cannot ask you the question why you are asking this information. This question cannot be asked. And also, if you approach public authority for information, and some other departments has, for example, if you are approaching the public authority now for the information and they do not have the information, but they know that other department of the same organization has the information, but they will send this application to that department. This burden is on them now, not on you. You will not have to search where this information would be available. They themselves will send this information to that department and get the information what is required for them. And this information should be given within the 30 days. And if the life and liberty of a person is concerned, then this information should be given in 48 days, on 48 hours only. It should be given within the 48 hours only. But still, this law, this Right to Information Act 2005, it seems very beautiful. But in this Right to Information Act, there are certain exceptions which makes it open for the criticism. Let's have a look at what are the exceptions to the Right to Information Act. Let's have a look at it. What kind of questions you cannot ask to the public authorities? First, you cannot ask the questions which can affect the sovereignty and integrity of nation. If the question is affecting the sovereignty and integrity of nation, for example, you cannot ask, recent there was Operation Sindoor. We could not have asked the question to the government how they are going to conduct the Operation Sindoor. It is eventually it would have impacted the sovereignty and integrity of the India. Affect sovereignty and integrity of India. Then if there is any question forbidden by the court of law, any question forbidden by the court of law, you would have heard about 2019 Ayodhya Ram Temple, a judgment in 2.77 acres of land belong to the Lord Ram. And in this judgment, the name of the author was not given. We cannot ask why this name was not given, because it was kept so that it would feel that it is from the it was the consensus there that everybody was involved in this judgment. So this name was not given, and we cannot ask who has given this judgment, who was the author of this judgment. Then what kind of information you cannot ask? If the information, if it breaches the privileges of the parliament, if the information breaches the privileges of the parliament, then you cannot ask such question. Fourth, information related to the fiduciary relationship. For example, the relation between lawyer and a client, doctor and patient, you cannot ask such questions. Especially lawyer and client. Fiduciary relationship questions you cannot ask. In confidence from the foreign government, what is the relation? What is the information which is in confidence with the foreign government? You cannot ask that. Or you cannot disclose the information which is going to impact the life and liberty of a person. And also, you cannot question the cabinet papers, including record of deliberation of the COM, secretaries and other officers. You cannot ask them. Once these are the cabinet papers which they write on, once they make up any policy, then it is open for the questioning. But during the discussion, you cannot ask what they discussed, what was the ideas behind it, or you cannot ask the the questions like relationship to any public activity. You cannot ask such questions. And eventually, these are certain type of questions which you cannot ask, which are exceptions under the Right to Information Act. So with respect to this, there is a saying that provided that the information which cannot be denied to the parliament or a state legislature shall not be denied to any person. Information which is not denied to the parliament or the state legislature, it shall not be denied to the it shall not denied to the what it shall not be denied to the to any common person too. So these are some limitations with respect to it. So what does this right to information lead to? A right to information led to the constitution of Central Information Commission. So let's see, let's try to find out key features of the Central Information Commission. Central Information. This governance part, it is very much boring, and I can feel the boredom right now. I am myself feeling very much boring with respect to this, but it is very much related to your mains preparation. You need to know about it. You have to collect these facts here. Please do watch the video till the end, and do consult my notes too, because these videos and my notes, they complement each other, and eventually it makes the preparation for you very easier. So what is the constitution? What does the it led to the it led to the constitution of the Central Information Commission. Let's see what does the Central Information Commission consist of. It consists of the Chief Information Commissioner, Chief Information Commissioner, and such number of information and such other number of Central Information Commissioners, which not exceeding 10. These Central Information Commissioners should not exceed 10. First, it should consist of Chief Information Commission, and not and such number of Information Commissioners not exceeding 10. Who is going to appoint them? It is the President who is going to appoint them. How the President is going to appoint them? Is it his own satisfaction? No, it would be recommended by the committee. What would be the composition of the committee? It is the PM, it is the leader of opposition from the Lok Sabha, and it would be the Union Cabinet Minister to be nominated by the Prime Minister. Union Cabinet Minister to be nominated by the Prime Minister. They will appoint the persons as a chief. They will recommend the names to the President as a Chief Information Commissioner and the Information Commissioners. Then the Chief Information Commissioner and Information Commissioner shall be persons. What is the qualification for them? Qualifications for them. The Chief Information Commissioner and the Information Commissioner shall be persons of eminence in public life, with the wide knowledge and experience in law. Wide knowledge and experience in law first. Also science and tech. Also social services, management, journalism, mass media, or administration and governance. He should have the expertise in these subjects. What are these subjects? Law, science and tech, social services, management, jurisdiction, journalism, mass media, or administration and governance. There are certain limitations to this. Certain restrictions to the Chief Information Commissioner and Information Commissioners. What are these restrictions? They can't be members of the Parliament. Can't be members of the Parliament. They can't be the members of the state legislatures. They cannot hold the office of the prophet. And what is the term of their office? Initially, it was 5 years, but in 2019, this was amended, and in 2019 it was amended, and this term maybe now the term of the office would be for such term as may be prescribed by the central government. So it in a way diluted this. It in a way put some control on the Chief Information Commissioner and Information Commissioner, so that the term of the office is under the domain of the central government. So there is no security of the tenure. It was diluted in 2019, and it is one of the drawback of this Right to Information Act, or we can say drawback of the Central Information Commission, or this amendment. And how long they can stand in office? Either till 65 years or decided by the parliament. For example, there is information commission, he would be promoted to the chief information commissioner. Then what would be his tenure? Then his tenure would be maximum 5 years would be his tenure, or 65 years of age. How he is removed? How they are removed? They are removed on the grounds of proved misbehavior or incapacity. So with respect to their removal, there is a catch here. If they are moved on the grounds of misbehavior or incapacity, then this matter should be transferred by the president, to whom it should be transferred to the high court. Otherwise they can be removed in different ways too. So let me write it here so that it will become clear to you guys. Ways to remove: proven misbehavior or incapacity. Proven misbehavior or incapacity. If these are the criteria for which the chief information commissioner or information commissioners are removed, then this matter should be referred to the high court. It should be referred to high court, and president can remove them. Otherwise there are other ways too for the removal. For these particular two, for proven misbehavior and incapacity, the matter should be referred to the high court. And for other criteria, for example, the person is bankrupt, or he has done any he is involved in the sexual harassment case, or he is convicted of that, or he has engaged in paid employment, or he is not of a stable mind and body, then the president can easily remove him. Now the question is, we discussed that what are the we discussed what is the exception to the right to information. We discussed that which is the authority to whom we can ask the questions, but we did not discuss one thing. What if the authority denies the information? What would be the penalty on them? So penalty would be, if you file the RTI and they are denying the information, the penalty would be 250 rupees each day till the information is furnished to them, till the information is given to them. If they for example, if they go beyond 30 days till information is given to them, they would be fined 250 rupees. But overall penalty, it should not exceed 25,000. The overall penalty should not exceed 25,000. And one more thing, for example, you are seeking the information from public information commissioners, then this central information commissioner and the state information commissioner, they can also recommend disciplinary actions against that. This is only the fine which is talked about, and the state information commission and the central information commission, they can also implement various disciplinary actions on them if they deny the information. Now let's move to the another topic, which is the analysis of the Right to Information Act. Analysis of Right to Information Act of 2025. Let us see whether it is a successful act, how it is successful, and how it is not so successful, and what are the various recommendations which should be, what are the various reforms which are most needed here. So let's try to understand that. First, let us discuss what is the success of the law. Let's try to find out various cases. For example, we have the absconding teacher, with respect to the Panchampur village. In the Panchampur village, there was a teacher who was not coming to the school, and the villagers, they tracked him and questioned the primary education department, and eventually the new school teacher was appointed in the Panchampur village. Then we have the case of 7 ponds in Odisha, where the people said that they had created the 7 ponds for people in a village, in Odisha, but those 7 ponds were not there. Then they asked for the Right to Information Act, and there was no such ponds, and eventually the officials were suspended and these ponds were created. Similarly, we have the cases with respect to school uniform. With respect to the private primary schools, that the schools had told that they had given the uniform, but when the RTI Act was filed, no uniform in this case is in Allahabad, and eventually this was made available to the children. And also the Commonwealth scheme, it was highlighted by this, the Aadharsh housing society scams. It was all this was possible only because of the Right to Information Act. So it has done wonders. The Right to Information Act has done wonders, but there are certain challenges which we can understand through the various reports. For example, there is second administration reforms, commission report, second administrative reforms commission report, ARC report. What does it say? This second ARC report, it has praised right to information. It said that right to information is the most powerful tool which the people can have. But there is an issue. First, there is lack of awareness among the people. Lack of awareness among the people about this. So they don't know what to do, how they are going to get access to this information. They don't even know is there any instrument through which they can get the access. So this is one of the drawback to it. Then there is a lack of awareness among the people. There is lack of information, even though the data is given to the people, but it is not satisfactory. The information is not satisfactory. And also there is issue of delay in responses. Similarly, there is another report which is Transparency International Report 2019. Transparency International Report 2019. It also says that this has done wonders, but there is an issue of the backlogging of the cases, and the information which is given, the quality of the information is not satisfactory to the people. According to this data, approximately 1,98,739 cases are pending. This much cases are pending. And according to Seeker survey, 75% of the citizens are not satisfied with the quality of information which is provided to them. And also there is issues of the these chief election commissioners and election commissioners. There is the issue with respect to understaff. First, it is understaffed. There is lot of vacancies, and there is, as the organizations have to create these offices. So for that they don't have the separate budget, so there is lack of budget too. Similarly, in 2019, if we look at in 2019, how the security of tenure was snatched. How earlier it used to have 5 years fixed time period, then it was put on the mercy of the central government, how they are going to appoint them. Similarly, there is also the lack of digital divide, even though the people want to get access to it, but there is huge digital divide. Then the lack of awareness among the people. So with respect to this, the Aruna Roy says, there is resistance from the public authorities. Anjali Badwai says there is, there should be the protection to the whistleblowers. When people file these RTIs, these big corporate mafias, what they will do eventually, that person either dies in certain accident or something bad happens to them. So there are various issues with respect to that. And also there is the lack of proactive disclosures. According to the Sutark Nagrik Sangathan, there is the lack of the proactive disclosure, as it is the first provision of the act that these authorities, they should proactively disclose the information, but there is lack of disclosure with respect to that too. And if we look at the states, what are the most worst performing states? In that, it is the Tamil Nadu, which comes at the lowest. Only 14% of the information is only 14% total from the total information. Only 14% of information is solved. That is, out of 100, only 14 cases get solved. And then after that is Maharashtra, which is also where it is 23%. And the best performing states, they are the Andhra Pradesh, it is Haryana, it is Jharkhand, Sikkim, and Tripura. They are good performing states. And there are not only these, these are associated with the structure of the RTI, but RTI as an act is misused by the money. For example, RTIs are filed for embarrassing public officials. RTIs are filed for embarrassing public officials, for blackmailing them. does not serve the this RTI. It does not serve the public purpose. There had been ridiculous RTI applications filed. For example, there was an RTI application filed which talked about what is the dinner manual for the governor in Tamil Nadu. Then there was another RTI filed which a man filed in Tamil Nadu, asked the authorities to let him know about the suitable life partners for him. So various such other stupid RTIs have been filed so far. And with respect to this, as I told you, there was a person, you know, Shailesh Gandhi. You know, now there are often people who say that, who criticize the Right to Information Act, that they say that in the Right to Information Act, the purpose of the Right to Information Act was good, but how it has been misused. But this Shailesh Gandhi, he says that he was the he was he was having an company, but he sold his company and devoted his time for the RTI, and eventually he was appointed as the chief information commissioner. And in his lifetime, he worked for 3 years as a chief information commissioner. He solved 23,000 of the cases, and he says that out of all those cases which come to which are filed under RTI, only 4 to 5% such cases are the ridiculous, whereas others cases are very much other cases, they make very much sense. And on this basis, the Shailesh Gandhi, he divided these RTIs, the divided on four. There are four types of RTIs which are filed in our country. First, the intention is very much clear, to expose corruption. And the second one is justice to themselves. They can file the RTI, but the broader meaning of it would be the justice for themselves. According to him, the most of the cases come under these two these two sections of the these two types. Then there is third type also, which is blackmail people. This is also one of the way why RTIs are filed. Then the fourth is harassing public officials to get undue favors. This is also one of the way these RTIs are filed. So according to him, even though there is a scope for misuse of the RTI, but still, according to the data, very less amount of the RTIs are filed which are ridiculous in nature. Then let's see what else we need to know about it. Let me rub it first. Eventually when this Right to Information Act came in, it was considered eventually it is considered the landmark act which the UPI government has brought in. It is highly respected because it has very huge scope for the better good of the people. So the governments also realized it. They saw that it can be misused against them too. And within 10 months, they tried to bring in the amendment. Amendment was proposed to the Right to Information Act. And what was the amendment? Amendment was we need to exclude the file notings. What are these file notings? When there is the discussion on any matter between two departments. So according to this Right to Information, according to this amendment, they wanted to exclude this file notings from the ambit of the law. Within 10 months, this amendment was brought in, but there was huge agitation and this amendment could not be passed. So, this has been this Right to Information. It is the landmark achievement which we had which we had achieved in our democratic journey from 1947. In this democratic journey, this Right to Information Act, it is the biggest achievement with respect to the democratic nature of our country. So with respect to this, there are various other issues with it. For example, during COVID-19, we don't know how many people had died. Similarly, census, it has not been conducted, and it is said that when the government does not want to give the information, then it does not need to put when the government does not does not want to give the information, they will not collect the information, and when they will not collect the information, then it will not put out the information, it will not give out the information, and eventually it is the citizens right to information which becomes restricted. And this is highlighted with respect to the census, how it has not been conducted yet. So this is also one of the drawback, one of the points which we need to know about it. And also how it is being misused. Another way, whenever, as we saw that, for example, if we will go to any department and ask for the information, if they don't have the information and they know which department has the information, they will forward this application to them by their own. But often it is seen that the departments or the divisions, what they say that this department or division does not have the information, only they give this statement: this department or division does not have the information. They only give this statement, and then this burden of finding out which department has the information, it goes back on the person who is seeking the information, and eventually it in a way restricts this right to information. And also uh, and also, as it was mandatory that every public authority had to give this so motto, they have to put out the information on the websites, but they are not doing so. There is lack of awareness, and also RTI applications are denied. They are denied. There is huge. They are highly denied. These applications. Then there is a question whether the political parties do come, whether the political parties, can we ask the questions with respect to them, which candidate they are, why they are giving this ticket to any particular candidate, how they are raising money. So let's try to discuss about the parties, political parties and right to information. Is political party a public authority? The first question, is it a public authority? Where from it gets its power? Is it a public authority within the RTI Act? We saw that. Are they funded by the state? Yes, they are funded by the state. Public political parties are funded by the state. How? They are indirectly funded by the state. They have the exemption from the income tax, which means that they are funded by the state. The states give them land on prominent localities, and when these political parties, they are recognized political parties, or they are the national political parties, they get free airtime on the Doordarshan and All India Radio. So at least, so eventually these political parties, which are recognized political parties or national political parties, they should be called as the public, uh, you know they should be called as the public authorities. They have to, they should be called as the public authorities. And eventually, with respect to this, RTI activists, they had approached these political parties for, they would try to seek the information. This information was denied to them, you know and eventually they approached the chief information commissioner, and chief information commissioner notified that six national political parties are the public authorities, and they will have to give the information if any information is asked from them. Then all these six national political parties, they approached the Supreme Court against the chief election commissioner's ruling, and now the case is pending in the Supreme Court. Let's see what does the Supreme Court will say about that. There are basically two big questions in front of the Supreme Court. The first question is, what sort of information are they going to ask? How they are, for example, if they are going to ask the question how they are planning to oppose the government on political matters, then such question cannot be answered by them. Then similarly, there is another question, how and why are you selecting candidate for the election? Such questions can, this is also this type of question which cannot be answered by them. So definitely this case is in the court right now, and let's see what will court say. And right now, till what we know, there are six national political parties which are the public authorities under the Right to Information Act, and it was this status was given to them by the chief information commissioner. So with this, we had completed our today's discussion. I hope you would have liked it. I hope you would share it with your friends, and I definitely hope you would subscribe the channel. Today's discussion, it is little boring. As I told you, this governance part is 50% of it is boring, 50% of it is very much interesting. But it doesn't matter whether it is boring or not. Eventually you have to pause the subject and you will have to read it. So don't worry about it, just read it, focus on the points which I highlight here, and then revise till the notes are available. So let's try to recap what we discussed today. First question what we discussed today is, what are the challenges to good governance in India. Here we saw there are three challenges. What is power dynamics is one. Then there is cultural negotiation. Then there is social there is social division. There is social division. Then after that we saw that what are the characteristics of good governance, what are the characteristics of the bad governance. With respect that in the bad governance we saw that we were discussing the in the good governance we saw that there is transparency. We started with transparency, we started to elaborate, and then we took the opinion of few experts what they say about the transparency. What does the Amartya Sen say, that he connects the transparency with the famines and the death of the people. Then eventually we reached to the Right to Information Act. How the Right to Information Act came in India, how it started, how the Right to Information Act came in, how there was an Aruna Roy, how she started an organization called MKSS, which is the Mazdoor Kisan Shakti Sanghatan, how they tried to get the information about why there are delays in the wages, and eventually they demanded it. Earlier the chief minister of Rajasthan supported them, but this act was not brought in. But what happened, everybody, we know that we discussed that how 150 villages protested, and it was the first time in the independent India that such protests was there, that people were not demanding the food or the employment, they were demanding the information. Then we started, then eventually the Right to Information was enacted in 2005. We saw its provisions. First we saw that what is the public authority, if it is defined by the constitution, if it is defined by any law made by the parliament, or any law made by the state legislature, or by any notification created by the government, or body owned or controlled or substantially financed by the government, or NGOs which are substantially financed by the government. Then all these institutions, the first provision was that will have to ensure to provide information suo motu. They should provide it themselves. Then we saw that if we have to request the information, for that we will have to approach the central information officer and the state public information officers. Then we saw that for there would be minimum amount of fee or the marginalized fee. After that we saw that what are the various exceptions in it. Then we saw that how it led to the constitution of the Central Information Commission. We saw that what is the composition of Central Information Commission and how they are appointed. After that we also saw that what would be the penalty if the right to information is denied. And after that what we discussed the analysis of Right to Information Act, how it is success. We saw certain cases like absconding teachers in Panchampur village, then case of 7 pounds in village of Odisha, school uniforms case in Allahabad, and then Commonwealth games scam, and the Adarsh housing society scams. We discussed them. Then we saw that how what are some drawbacks associated with it, what are the limitations to it. Then we saw that there is Second Administration Reforms Commission report. It says that there is delay in responses, lack of infrastructure, awareness among people is less. Then we saw that Transparency International report, and we discussed that, and eventually we discussed everything. I don't want to repeat it again. So with this we had completed our today's discussion. I hope you would have liked it. I hope you would share it with your friends, and I definitely hope you would subscribe the channel. Thank you for staying with me. Thank you very much, and have a nice day.